Welcome to the About podcast. Here we explore your financial health in simple and easy to understand ways.
All right, well, welcome everybody back to the About podcast, where we tackle everything personal finance related and, occasional tangents here and there. My name is Jeremy Scott, and I am ably joined, as always, by Roy Hucke. Roy, how you doing today?
I'm awesome and excited for our awesome guest today.
I love it when we have guests.
It's much better when it's just you and me.
Before the mics went on, we were talking about how it's so much. We've not had a bad one when we've had a guest on.
I work with quality people.
You do. Roy only knows good people.
Yes.
So you know me. So obviously,
exactly.
Your standards are high. So today we're actually joined by Brian Budman, attorney at law, specifically a state attorney, if I understand that correctly. Brian, am I right in that one?
You are right. That's what I do.
Fantastic. So I think one of the big things, just trying to get us going, is what does that mean? Like, what do you deal with in a state law? Just kind of set the table a little bit for folks at home.
Well, essentially, I give people peace of mind, and what that means is that I plan so that people understand what's going to unfold in their lives should they become incapacitated or upon death, and we try to do it in a really thoughtful way, so that we make things good for the next generation or for your heirs.
Nice.
Yeah, and in full disclosure, Brian and I have been working together. What has it been? Probably 15 years now.
It's been a long time.
When I started my career, I was actually working out of another advisor's office in Greeley, Colorado. And that person actually had a family member have to write $1 million check in estate taxes to the government.
Whoa.
And she was bound and determined to not ever let that happen to any of her clients. And she actually was going around and interviewing attorneys.
Oh.
And when she was going in, she was finding that she knew more than them sometimes. And you get sometimes attorneys that do a little of this and a little that, and it says specializing. Well, then finally she went to some seminar and met Brian, and she was blown away by the presentation that you gave. And that's how she had him coming into her office. And that's how I was introduced to Brian, actually.
Oh, that's
15 years ago.
Wow.
Right, and she did a lot of, she made sure that all of her clients had a proper estate plan in place.
Mm-hmm.
And I think that gave her an edge among her peers, because there's a lot of advisors who work on accumulating wealth for their clients, but then they don't plan on that succession. What happens when their clients become incapacitated or die? And so she was intent on making sure that her clients were all well taken care of.
Yep.
Yeah. One of the things that comes up a lot that Roy's educated me on is just that reality of, obviously I know that taxes are a thing, and they're somewhat unavoidable, but they're also, you can plan for them and manage them. In our incredibly exciting episode on Roth conversions, which is still
it was dynamic.
It was a highlight for me. The biggest surprise was how
he really liked it.
I really did. But the purpose of that and everything. So I'm curious, was estate planning, is this what you planned to do when you went to law school? You're like, I'm going to go be an estate planner, or do estate law, or is it just
give us that backstory?
In law school, when they talk about wills and trusts,
yeah,
you kind of think that's not dynamic, it's not exotic, there's no sex appeal.
Right.
So most people stay away from that. And so, of course, like many law students, you want to be doing corporate law, or you want to be doing litigation. You want to be out there, you want to be one of those lawyers that you see on television.
Right.
They don't have any shows about estate lawyers or tax lawyers, right? There's just no interest. So, but after I got out of law school, I actually graduated from a Canadian law school. I'm from Canada originally.
Oh.
So I graduated from Queen's University in Kingston, Ontario, and I married an American. And so we moved to Colorado, and I was looking for work at the time, and I stumbled upon an organization that provided support for estate planning lawyers throughout the country. And when I got involved with them, I was actually presenting to lawyers from all over the United States about how to build an estate planning practice.
Oh.
And I remember that we didn't have much credibility. There was a group of 3 of us who were doing that. We were all lawyers, but a lot of the members were like, well, if you really knew what you were doing, why are you here? Why aren't you out there?
Oh.
So I went out there, and I just did what I was teaching lawyers to do. and I built up a nice practice, and I raised 2 lawyers of my own. My 2 children are lawyers, and both of them are involved in this same area. So it is exciting, and one of them's joined me, and the other one went to the competition, but she'll be back.
Actually,
they always come back.
I have a clergy colleague. She just retired, but her first career, she was an estate planner, and she actually did that. She worked in smaller churches and did part-time church at work, and she was always doing estate work. And she's like, yeah, I need to retire. I'll be doing this forever. There's no end of work. She was like, there's no end of what I could do if I wanted to, and but yeah, I mean, she actually really enjoyed it. She said it was really.
I think it's a great area because I think you make a difference in people's lives, and if you plan properly, you can really do some good things. And like I said at the beginning, like we give peace of mind to people. That's what we do.
Yeah.
I just returned from a conference, and I was in Nashville and Chicago, and 2 different conferences, and the biggest theme was estate planning.
Really?
And how it's a big deal right now, and how in the industry in general, it's still one of the areas that are most undereducated for just normal Joe Schmo to understand on what is needed and why. And there's some big changes coming up here potentially, Brian, in 2025. Can you tell us a little bit about that?
Oh yeah, at the end of 2025, the Trump era tax reform, the tax changes that Trump put in place are scheduled to sunset at the end of next year, at the end of 2025. So I suspect that next year we're going to have a lot of lawyers out there trying to sell products as a way to beat the drop in the amount of assets that people can transfer estate tax free when they die. So it's going to be an interesting year, and it's, I guess the upcoming election is going to give us some insight into whether or not we're going to see this actually happen.
Right.
So what is the current number, and what will it potentially go to if nothing's done?
Well, right now, each taxpayer can transfer a generous $13.6 million of wealth to whoever they want. And so if you're a husband and wife, you can transfer over $27 million.
And when you say transfer, what does that actually mean to just someone who doesn't understand all that?
Well, there's a tax on the privilege of being able to transfer wealth. So a lot of people are concerned if they've done well and they've invested and they've saved and they've built up wealth, or they have a business, that is going to be devastated in the event of their death when they pass it on to their loved ones. And so, but right now, under the law, the value of those assets, to the extent that they're below $13.6 million, can transfer without a transfer tax, without an estate tax, a dreaded estate tax.
And on one hand, like, okay, so as a pastor, I can say that sounds like a lot of money. But if you're a small business owner, that's not a very big small business.
Think of the small farms and ranches around the United States where they have assets and they have no liquidity. They don't have really a lot of cash flow.
Right.
But then you pass away and boom, you're hit with a huge tax. And how do you pay that tax?
Right.
You have to liquidate and sell the farm.
Especially in this part of the world, land value alone.
Yeah.
I mean, you could.
That's right.
It's not. So if people are like tuning out, going, "Well, I don't have $13 million," like, well, maybe not, but I mean, or maybe not cash in the bank. But there's a lot of ways to accumulate that level of asset, and I think that's the big key there. We're talking about assets,
and that's today. And if it sunsets, what's it potentially going to go to?
It's supposed to go back. It's supposed to revert to where it was pre-Donald Trump's reforms, which is what President Obama put in place, and he had it at $5 million adjusted for inflation. So the belief is that it'll probably just drop in half. So if it's at 13 point, if it might go up next year because of inflation. So let's say we're at 14 million, then the thought is that it'll drop down to 7 million per person.
Right.
And that's going to hit a lot of Roy's clients, I think, right? Right?
That's right.
So, yeah. Well, and that's a number that even more so. I mean, again, you don't have to. If you're, we have people here who have, they got rental homes or whatever. I mean, you start adding up what you accumulated throughout your lifetime. If you've been, especially if you've been in any kind of entrepreneurial or again been involved in small business or whatever. I mean, you can hit that number.
Well, and the difficulty is this is about planning, right?
Right.
So when you're talking about these numbers in today's dollars, it sounds like a lot. even inflation adjusted to the future. But if you're working your whole life and your whole career and you save up assets and then those assets appreciate, and you can easily hit those numbers. And the value of our dollar is not going up, it's actually going down. Right. So more dollars needed to buy the same piece of whatever it is. And that's going to continue. Yeah. So with that design, these numbers that are hitting hard caps are really important to really more people than they understand.
Well, with inflation, the value of everything has gone up, including real estate.
Yep.
And also, I mean, the stock market has hit all-time highs this year, and so people's portfolios are up, and so and sometimes things get included in that number that people don't realize, like life insurance death benefits, if they're not structured properly. So if somebody has $1 million life insurance policy, that's just added on to the value of their taxable estate.
Oh,
they own that.
Yeah, that is a misconception. People think it's tax-free for life insurance, which it is most of the time, but not all of the time.
Well, it's income tax-free. You don't have to pay income taxes on it, but it could be included in your estate.
Yep.
It's not held properly.
Yeah, that makes sense. So obviously the estate tax, that's a big issue, and for especially people who have, any kind of wealth accumulation, that's going to be, something that they have to pay attention to. But that's not, that's the tip of the iceberg when it comes to estate planning in general, is my understanding. There's obviously that's a big part of it, but that's not by any means if you're not worried about that, actually, well, I'm broke, I don't have that. Or, I'm never going to have that much money, so then I don't have to worry about estate planning. Like that. That is not true either. There are other things and other concerns I'm sure you're dealing with more than just, structuring people's, assets.
Let's set the table a little bit, Brian. So if somebody doesn't decide to work with an attorney to set up an estate plan of any kind, what happens?
Well, the Colorado, like most states, has a plan in place for everybody.
Yeah.
If you die and you don't have a plan in place, then Colorado law provides for how your assets are to be divided, or what the succession plan is. So you can get away without having a will, but the outcome may not be what you want, right? Particularly with second marriages and stepchildren, it may not unfold the way you want. So that's a good reason to look at doing some planning, or at least getting some information. Yeah. The other thing is incapacity. If somebody becomes incapacitated and can't make decisions for themselves, it gets pretty expensive if you don't have a simple power of attorney in place. So I know when I work with Roy, he makes sure that his clients all have powers of attorney, just to be sure that someone has the authority to act for them should they be unable to do so.
Yes, he does.
Yeah, he does. And one of the other things that I think is important that people overlook is how you transfer wealth. So even if you don't have a taxable estate, you've worked hard to build up what you have, and you probably want those assets to transfer to your children in most cases and be protected for the benefit of your children. Mm-hmm. And you want to ensure that those assets are not going to be lost in a divorce or in a bankruptcy. So we focus heavily on asset protection in structuring the way a beneficiary is going to receive their inheritance. So one of the things that you can do is you can give a beneficiary a significant amount of control over their inheritance, but you don't give them ownership. And that distinction is what is going to give them asset protection. And we like to set things up like that. And very frequently there's a reason to have assets transfer in trust other than asset protection. Like you're concerned about the spending habits of your children, or their level of responsibility, or the choices they make. So we can create thoughtful ways to transfer wealth.
Yeah.
So at a minimum then, what people need to have is a will. They need to have their powers of attorney so that if they're incapacitated but not deceased, that somebody can make decisions for them. And then there's this thing called a living will. What the heck is that?
Well, that's instructions. It's called a living will or a healthcare directive. And that's a form that's available, in Colorado has its own form. And in that form, you can specify what you want your agent, your medical decision maker, if you've authorized someone to be your medical decision maker, to do in various situations, like if you're in a vegetative state or you're in a terminal condition. And so what we've done is we've made our living wills more robust to try to give people more things to think about and give them the opportunity to make decisions ahead of time that their agents can follow. And it's a good thing to have, because very often people are faced with having to make a decision and they just don't know what to do.
How does the HIPAA laws apply to any of that stuff? How does that work? I feel like the HIPAA is kind of convoluted, and do you have to make some plans for that, or how does that work?
Well, I've seen that. In fact, I had a client in yesterday who was saying that her grandmother was in the hospital, and she was having difficulty with the staff because they told her that since her grandmother didn't have their specific HIPAA form, that she couldn't get information. And she had a HIPAA form. I mean, I was the lawyer who drafted the plan for her grandmother, and included as part of that was a HIPAA form, which authorizes the release of medical information to the people who you designate. And in fact, you don't have to have a specific HIPAA form. If you're listed as the medical agent for somebody, then you automatically will have that HIPAA authorization. But nevertheless, I mean, I explained to her that was nonsense. If she had a form, her grandmother signed it and said that she's authorizing this granddaughter as a personal representative under the HIPAA rules. And so, unfortunately, I mean, she had to fight them before they were willing to give her that information. But she had it, and she was armed with that, and being armed with that is the key.
So did you have to step in, or did she just have to go to them and say, hey, here's the paperwork?
She was pretty tough, so I didn't have to step in. But sometimes people contact our office because not only with issues with HIPAA, but powers of attorney. Mm-hmm. And generally, if we intervene, we can convince whoever's preventing them from using the power of attorney or getting the information with a HIPAA authorization. We can persuade them that they should be allowing that. Right. For various reasons.
So, okay, so we kind of got the basics, the will, the power of attorney, the living will, right? The HIPAA is part of all that process. And then you mentioned trust earlier, right? So I want to kind of talk about this a little bit, because people throw the word trust out there and they don't actually know what it means. So there's a thing called a testamentary trust. Let's just start there, because a lot of my clients who have children, they say they have a trust. I'm like, well, what does that mean? And they can't explain it to me. But I just seeing it a lot. I think it's a testamentary trust because of them having young children. You know, it's kind of the design I see a lot. But explain that to us.
So testamentary trust means that it's a trust that's going to come into existence as a result of their death. So it's probably provisions for the establishment of a trust that's included in their will. Right. So in their will, they have provisions that say, you know, in the event of my death, if I don't have a surviving spouse, I want my assets to go into this trust to be managed by this trustee, and the following are the instructions that the trustee has to follow. So a trust really is a set of instructions that it's a contract. You put this set of instructions in place, and you designate someone to carry out your wishes, the trustee. Mm-hmm. So you created it, you have a trustee, and you always have beneficiaries. Those are the three parties to a trust. So there's different kinds of trusts. In Roy's example, a testamentary trust is one that's created through your will or through a revocable living trust, but it comes into being at the time of your death, and it holds assets. The issue that we see with that often is that people do have these testamentary trusts, and they also, through their investing, they'll designate beneficiaries on their assets. So Roy said, I have a client who has minor children, and they have a trust that would come into existence through their will. However, they've taken steps without putting much thought into it to designate their children as beneficiaries or contingent beneficiaries on their assets. Mm-hmm. Like they will have a life insurance policy designating a spouse, and the contingent beneficiary will be their children. You know, and not thinking that, well, I've got minor children. So that is going to undermine the planning that was done through the will. So if somebody passes away with a life insurance policy made payable to a 10-year-old or an 8-year-old, then the problem is even though they have a trust come into existence through their will, those assets go directly to the beneficiary. And in that situation, the beneficiary is a minor and unable to, is considered incapacitated essentially in the eyes of the law because they can't enter into contracts. Right. And so somebody has to be appointed by the court to manage that death benefit for the benefit of that child. And the frustrating thing is that the parents took care of it all. They put something in their will to deal with it. But it's not going through the probate process. It's going directly to that beneficiary.
Because a beneficiary designation supersedes a will.
Okay.
Okay, so it's important, and so I'm bringing that up because for my clients that I onboard that are new and current clients, I review that stuff because I see a lot of times it's not funded properly. Right. So typically when Brian works with a client, he'll give me specific directions on how to put beneficiary designations on everything. Mm-hmm. And then I can only control the assets that I oversee for the client, but I can encourage the client to make sure and get it done. And then I follow up with them and make sure they did it, or engage Brian's office to do it for them on their behalf. But that's a big issue where it's not, you do all this planning and then they don't set it up properly, right? It's not just get the piece of paper, it's make sure we do all the little pieces.
Yeah, I've over the years, I think it's more important that there's coordination between people's advisors. That's what I've seen. If your lawyer is not talking to your financial advisor and your financial advisor is not talking with your accountant, I think things can get out of sync. And so there has to be some symmetry with all of these advisors and all of the documents that you have.
Yeah. One of the things I know Roy's warned me about is we're going to have to do this whole conversation because I just got remarried and now there are, my kids and stepkids and, I've got one kid that's, 19 now and one that's still, underage. And so it's not a mess, but it's definitely going to change things. And I think sometimes the reason that people don't like to think about it is that you have to have, there's a conversation that me and my new wife are going to have about, okay, we both carry life insurance through our work, right? Well, you've got your kids to worry about, and I've got mine, and and then she's got an ex-husband out there, and all that too. So I mean, it's just we have to kind of figure how do we want this to work, and who's going to be responsible for what? God forbid, something happen, to one of us. And so,
Brian, perfect example. Let's use their scenario. Do you mind if I use your scenario?
No, you can use my scenario.
So, Brian, let's say that they don't do anything, right? And I'm going to assume there's nothing in place in this scenario. I know you do, Jeremy, but let's just assume nothing's in place.
I was going to say I wrote a check to somebody, much like our buddy Brian over here at one point, to make sure there was something in place. But yes, pretend like there isn't.
But let's pretend like there isn't because that's what a lot of people do.
Yeah.
So remarried, as you know, and we've talked about on this podcast, Jeremy's spouse was deceased, and his current spouse is his new spouse, I should say, has an ex, and she has 2 children. And Jeremy has 2 children.
Well, Jeremy said he has something in place.
Well, I'm trying to run a role play though, just to say
I don't.
Say you don't because
I'm also curious to know what he has in place.
Yeah, we'll talk about that. Yeah. So nothing happens. So if Jeremy's remarried, there's no will. It follows the Colorado law at that point. What happens? Explain to me what that actually means to Jeremy's assets and his potential children in their asset and their inheritance.
Okay. Well, under the assumption that there's nothing in place,
right.
And let's say there's not even beneficiaries designated.
Yeah.
So if Jeremy passes away, his estate now is going to be controlled by the state of Colorado. He's a resident of Colorado. And so under the law, his surviving spouse is going to be entitled to a portion of his estate, a larger portion, and his children are going to be entitled, his natural children will be entitled to something. But when all the dust settles, his surviving spouse, who's not the mother of his children, is now going to have control over a large portion of what Jeremy had. And so the likelihood is that as time goes on, she may not maintain contact with his children. And so most of those assets are going to end up going to her new spouse or her children or wherever she wants it to go.
Is there a percentage number that they put on that, or is it just argued?
There is.
Argued.
So a surviving spouse is entitled to a certain amount right off the top, and that number is, let's just say it's $80,000, and then she's entitled to, and of course I don't have the statute in front of me, but I'm going to guess that it's 3/4 of the estate, and his children, his natural children, will get 1/4 of the estate.
Okay, divided between them.
Yeah.
Okay, so then for my son who is over 18. He would just get that.
He would get it outright.
But my daughter, who's not, whoever then becomes...
Somebody has to be appointed as her
The state
conservator.
will appoint somebody.
Yeah. Right. And I guess if we're going to say nothing's been done, then, the assumption is that, the assumption then would be, I think, that my new wife has not like adopted my daughter or anything, because that actually,
That might happen.
it could.
Yeah.
It's part of the conversation, right? Like that's part of where, and it's not an easy conversation necessarily to have either. So I think that's again why people tend to avoid it. But it gets messy. I mean,
blended families are very, very
well,
difficult.
it's the
And they're so
expectations
common.
are not met. That's the problem.
Right.
Like, I mean, just fast forward 20 years from now. If something happens to you then and you're still in that same position, your children might have certain expectations.
Right.
They're young now, and maybe they're just not thinking about this kind of thing. But as time goes on and they're building their own net worth and building up and having their own families, they might feel like, well, dad should have left us something.
Right.
Right.
Yeah.
But you can plan to make sure that things unfold the way you want.
Mm-hmm.
You can take care of a surviving spouse, but also make sure that your children are not disinherited.
Right.
And again, I mean, the way to do that is using trusts.
Yeah. Right.
Because a trust, again, what it is it's a set of instructions. Mm-hmm. Okay. So under Colorado law, you can't disinherit your spouse. So you have to really put some thought into the plan and make sure that you have the appropriate instruments in place so
you
that you
can't
can do it.
disinherit your. What is that? I don't like.
Well, like if you decided that, my spouse has her own assets or her own ability to generate income.
Okay.
I'm just going to leave everything I have to my kids. That might not work out for you.
Oh.
So you have to make sure you've taken care of things and you've done it under the provisions of the law.
Okay.
Yeah. So very, very, very messy.
Yes.
Which is why when I have blended families, I mean, an attorney is necessary.
Well, I just the glimpse I had into this because when my late wife passed, it was very unexpected. It wasn't anything anybody saw coming. So we didn't have really anything in place at that point, and I found myself really grateful that our situation was fairly simple, right? Like the only kids we had were our kids, and when I went through the whatever the easy probate process, whatever they call that in Colorado, the simplified one. Very lovely people, by the way. Shout out to the people at the probate office in Weld County. Lovely people.
That's nice to hear.
And were super easy to deal with. That was probably the simplest part of the whole process in a lot of ways, but mostly because our situation was simple. My kids were both under 18. We'd only ever been married to each other. Our kids were both ours. I mean, there wasn't anybody else. She was an only child even, so she didn't even have siblings. There was it just all kind of followed the path that it's supposed to follow. Right. But I've thought about that since. I'm like, oh, my situation is far more complicated now.
Yeah, you're in a different situation.
Oh, yeah.
Because in that case, if you didn't have a will, the surviving spouse, you would be entitled to everything.
Yeah.
Because the children were joint children.
Yeah, and thankfully I was the named beneficiary on most everything, and all of that, and we didn't muck around with anything. So I could see as I was going through that, I'm like, oh man, this could get messy fast.
Yep, and this is why the planning piece is so important, and it's also why the beneficiary designations are equally important to review, because people will tell me they have a plan, and then I'll ask, well, what's the beneficiary on this? I don't know. Well, what about this? Well, I think it's that. Well, we need to confirm all of that stuff, right? Because it's a problem to have that not confirmed to follow what you want to happen in the estate plan. However, there is a way to not have that match the estate plan on purpose sometimes. One of the things that, you appreciate this, Jeremy, as a pastor, right, is the IRA could be designated to have some of that money go to a charity, potentially.
Yes.
Right? That's if the person's charitably inclined. And you could also say that in the will process, but sometimes it's just easier and simpler to just say 10% of my IRA or whatever goes to a church entity or a nonprofit organization.
Yeah, I know the couple of the foundation development groups, that's one of the things they encourage people to do is just add that one line that says, after all the dust settles, 10% goes to, whatever, and basically a tithe on your estate. Yeah,
and I actually saw a situation where the client was having they wanted to pass $1 million on a charity. It was really important to them, and it was going from their trust. And they had a $3 million IRA, and I'm like, why don't we have this going from the IRA, which the church doesn't have to pay tax on, and you don't have to pay, your estate doesn't have to pay tax on, or your people who inherit the money.
Yeah.
And so they relooked at it and actually ended up making the change. But It's like that was simple in my mind, but I'm like, why didn't the attorney catch that?
Yeah, that wasn't one of my clients.
No, it was not one of your clients, Brian.
Well, I think there's, it's in some ways it's straightforward, in some ways it's not, and there's knock-on effects to everything, right? And, taxes are a big piece of that. We talk about taxes all the time on this podcast because it's one of those things that's just lurking out there, it feels like sometimes, and you don't know when it's going to come and grab a bite and when it's not and when you can avoid it and everything, and that's why planning, is so important because there's things you don't understand. I wouldn't have known myself that the beneficiary designation trumps the will.
Most people don't.
But I guess it makes sense. In a way, something's got to win, right? There's got to be some order of operations there. Like
right.
So it makes as much sense or less sense than anything else does. But you just got to know.
And I might have shared this on a previous, and I'd be interested to hear if you've seen any of these things too. But a fella got divorced. He had a son. He had $1 million life insurance policy. Everything in his will said it goes to his son. Well, his son was young, right? So he didn't name the son or the estate even in the life insurance. He named his sister. And as the son got older, they never changed it. And when he passed, suddenly actually, that death benefit went to his sister and not to help his own son. And the sister had no obligation to give it to him, and she didn't.
Yeah, that's why a review of your beneficiary designations is probably a responsible thing to do because, even cases like yours, sometimes people have a life insurance policy that's made payable to, well, not in a case like yours, but in a case where it's in a second marriage, they haven't changed it to the new spouse. They have the old spouse listed. Or same thing with retirement accounts. So you got to look at these things. And Roy's case is a great example. I've seen that happen. He's right. The sister has no obligation to return the money.
Yeah.
In fact, I saw that. You ask about that. I saw that recently where somebody died. This woman died, and she left a big life insurance policy to her brother, and she had a minor child. And the brother was obviously the reason why his sister left it to him was because she wanted to make sure that it didn't go to her minor child.
Right.
But it was always intended to be used to raise the minor child. And after it happened, this brother was, met with me, and he was ready to go. He wanted to do the right thing. But after a few months, as time went on, I guess he realized, well, I've got my own bills that I have to pay and things that I have to do. And it wasn't as important to him to make sure that money was used for his niece. And it was very sad because she may end up getting just a fraction of that, which was never the intent of his sister, the mother of that niece.
Right. The nice thing, Jeremy, is that Brian mentioned earlier that he can help people protect their estate, right? So you floated a word out there, Brian, that I want to make sure people understand. There's two types of trusts. Let's just start high level. Let's do revocable. You said revocable living trust is what you actually said. And is there also something called a irrevocable trust?
Yeah, so a revocable trust is used by a lot of people as a replacement for a will. So instead of using a will, they'll use a revocable trust. And essentially, a revocable trust is just an alter ego. It's a trust that's designed to hold the creator's assets. Okay, and so the creator typically it maintains the responsibility to manage those assets as the trustee, and the creator is also the beneficiary.
Okay.
So they're one and the same.
Yeah. So Roy could create a trust, move all of his assets into the trust, and continue to benefit from those assets. And the purpose of that trust is to have a way to ensure that there's a simplified administration should he become incapacitated or upon his death.
Okay.
So it doesn't do anything for asset protection. Those assets, as available as they are to him, they're available to his creditors.
Number one thing that people say to me is that they have protection because they have a revocable living trust.
Right.
They have zero protection.
Right.
So as they get older, and if they're facing maybe a long-term nursing home stay, they might think, well, I should be okay. I put everything into a trust. But since they're the beneficiary of that trust, and they have full control over that trust, they can dissolve the trust if they chose to. Then those assets are not protected against a spend down in order to be eligible for Medicaid.
Okay.
So that's kind of a misconception.
Because it's still an asset. It's still an asset. Whether it's whether the money or whatever assets are with the trust. I mean, it's still yours. You put a layer in between you and your assets, I guess.
Yeah. Well,
but it's still an asset and it's still yours.
It's your asset. You move the assets into a trust, but you continue to hold on to all of the benefits of those assets. You didn't give anything away.
I always tell people, because I'm a visual learner, think of just a box without a lid.
Mm-hmm.
My trust is my box. I put all my assets into it. There's no lid. There's no protection. There's nothing. I can take it in. I can pull it out. Doesn't matter, right?
And so can other people.
Yep.
Or
if I get sued or if I go bankrupt, everything's at risk because there's no lid protection, right?
Right.
Yeah, that makes sense.
Or the long-term care, I think, is the more, especially that one, is a very real example for people too.
Yeah, a lot of people
because as people get older, they get concerned about if they haven't taken steps to protect themselves against a long-term care nursing home stay.
Yep.
So that's a revocable trust. Now, an irrevocable trust is it doesn't have to be that different. You're just saying, okay, I'm putting these assets into the trust and I'm making that transfer irrevocable. I can't get them out. But you can create an irrevocable trust where you're still the beneficiary.
Right.
And so those assets in that case may not provide you with any protection either. So the idea is you've got to fund the trust, you got to move your assets into the trust, and they can't be for your benefit. They have to be for somebody else's benefit.
Oh.
And so an example of a Medicaid plan might be, well, let's move our assets into an irrevocable trust and just reserve the right to the income from that trust, but not have any rights to the principal. I've given that away, right? So during my lifetime, I'm entitled to the income from that trust. But let's say that something extraordinary comes up and I need $25,000. I can't reach into that trust and get that $25,000 because I'm not entitled to it. I've given it away. It belongs to the remainder beneficiaries of that trust.
So then, visually again, you now have a box with a lid.
Right.
I can't take anything out of it, essentially.
Okay.
You technically could, I guess, irrevocably add more assets to it, but you can't take it out.
But in his example, his visual, there's a spigot on that you open it and the income can come out to you.
Right. Okay.
But nothing else.
Okay.
And so in that case, if you're applying for Medicaid, and keep in mind we're just simplifying things because there's other things to think about, like you have to have made that transfer prior to 5 years ago, right, for Medicaid eligibility.
Right.
In other words, if we do this and tomorrow we apply for Medicaid, it's not going to work, right? Because we've given, the state is going to say, well, you gave it away because you're trying to qualify for Medicaid.
Right.
So it has to have happened 5 years previously. Okay,
makes sense.
So, so that's a good thing. So we can give assets away and get them out of the reach of our creditors, including Medicaid. But you've got to plan it properly. You've got to give something away. You no longer can have control and be able to retrieve those assets. And it's not always about an irrevocable trust. It's about what I say. It's about who funds the trust and who is it for.
Right.
So if you think about it, when somebody passes away and they no longer need their assets, they can give them directly to a beneficiary, and now that beneficiary owns those assets. It's the property of the beneficiary. Or they can put it into one of those boxes that Roy's talking about.
Right. And
create different sorts of spigots into that box. Such as you can say that, well, if the beneficiary, if my son is productive, is a contributing member of society, then turn that spigot on and let him take the income.
Right.
Right? Maybe we can lift the lid and reach in and pull something out every year, but we're limited to what we can pull out. So you can control how and when your beneficiaries get their inheritance. And now what happens if if that same beneficiary goes through a divorce? Now, are the assets in that box the property of the beneficiary? They're not, right? And so if you give the discretion to an independent trustee to turn on and off that spigot, then that independent trustee in that situation is going to say, well, I'm going to exercise my discretion not to turn anything on. Okay? Now, if something is turned on and it comes out, it belongs to the beneficiary. Right. But if you turn that off, it doesn't belong to the beneficiary. And as a result, you have a box that is completely protected against the creditors of that beneficiary. Gotcha. And I think people like that. I mean, you work hard for what you've built up, and people have sacrificed. I think in a lot of cases, people make sacrifices to build up wealth. And so I think that it's important to a lot of people to make sure that wealth goes to where they want it to go and is used for the things that are important to them.
And to protect their beneficiaries too. And unfortunately, and you know this, with I can't remember the gentleman's name that we had come to church with substance abuse, but he was specifically talking about people who are really struggling with addiction.
Yeah.
Right.
Brian.
And I know a lot of clients that have children or grandchildren that are experiencing that.
Right.
And what Brian's talking about can help protect them from themselves,
right.
because they can say, well, no, spigot's staying closed because we're not going to help you, attain what you need to get your fix. It's only if you're a productive member of society. It's only if you're clean or you need to go to rehab. Or anyways, there's lots of things that can be done to protect them from themselves,
right,
and not just give them a blank check to go and basically kill themselves.
Right. Well, and I think that's important for people to understand too. There's options between, I'm just going to write that person out, completely, because at this particular moment in time they don't have their life together. And that's the thing, is like when you're putting your will together, or all these documents together, you're dealing with a moment in time, and things can change and shift. And so being able to build a plan that's got the ability to have, some decision making after the fact, with trusted people, I think that makes sense, because, you may say, oh, my grandson, he's ne'er-do-well, whatever. But between the time you put your will together and exclude that person and the time that maybe you pass, maybe they go to rehab, they get, they find Jesus, right? Or whatever, and they, get their life put back together. Then it would be nice to have, a mechanism in there for, supporting that person. So,
well, I think that's a good point, because I think that a legacy is very important to people.
Yeah.
And I think that, and I tell people that when I have clients who come to me and say, well, we're going to exclude my son, right? And sometimes they don't want to get into the details, but they're, the son has done something to upset them. And so they just decide, I'm going to exclude them. And so what I try to encourage them to do is to take the share that was going to go to that son and maybe hold it in a trust, and maybe give the son's children the access to that trust, controlled by a trustee, rather than just simply excluding that child, because you can't come back and do it over after you die.
Yep.
And this is what people are going to remember. They're going to remember, he did that. And
right.
And the problem is that when you exclude that child, you're excluding their children. And what did their children do to deserve that? Right? Nothing. Yeah. So in that situation, you're saying, look, this is not that I don't love you, but I'm doing this because, we had our differences, but I'm not taking this away from your family. I'm just, rather than it going to you, I'm going to have it go to your children. I'm going to use it for the benefit of your children.
Right.
And it's important to think that. And it's also in situations where somebody's lost a child, right? Let's say somebody has 3 children and they lose a child. And so now they say, okay, well, my estate's going to go to my remaining 2. And I always ask, well, did that child who died have children of their own? And they'll say, yeah. And I'll say, why don't you leave something to them? And they're, well, we're not going to include any of the grandchildren. But I remind them that if you leave everything to the 2 kids and they were to die the next day, it's their children that are going to get it. Now you've excluded the children of that deceased child. And so I try to get people to think about these things and make good choices about how they want to pass on their estate.
Right.
And also to ensure that they are remembered fondly, and they're not looked as vindictive. And I think that it's important for people to have that and know that.
I think a big area where I help, my profession helps, maybe not as much as we should, but when somebody receives an asset and they don't understand the planning that goes behind it,
mm-hmm.
how do they use those assets? So for instance, I actually have a situation that Brian helped me with where there was 3 children that I didn't know any of them. One decided to come to me to get help when they received an inheritance.
Mm.
Well, the person that left the money had a trust created, and it was to be received. They could receive it in trust and have that protection still on it, right? So again, if that person went bankrupt or got divorced, that's the asset's not part of that to be at risk, right? Well, so we did it. I got Brian's help with this to then make sure we received it properly so that all that protection remained. And the other 2 siblings just took an outright distribution.
Mm-hmm.
No protection. None. So if you don't understand what you're receiving and how to receive it, then you can make mistakes for all the planning that occurred in advance, right? So same thing, if you have money that you've received in this irrevocable trust and you want to buy a house, well, do I have to take the money out of the trust to buy the house, Brian?
You don't have to. You can borrow the money from the trust. You can do it in different ways. So if you borrow the money, you haven't really reduced the value of that trust. you take the money out in exchange for a promissory note.
Right.
So you owe the money back to that trust.
Yeah.
Or the trust could purchase an interest in that property you want to buy. So there's different ways to do it, and so it's always worth having a discussion.
Yeah.
And so the old days where people would create these trusts and they'd have some bank managing it, and the beneficiaries felt it really difficult to deal with the trust department at the bank. I mean, we've learned a lot since then, and we can create these trusts that are much more flexible and much more user-friendly for people, but also provide them with that asset protection.
Yeah. Well, I think it goes back to that intentionality, like thinking through and seeing like what, like I'm sitting here going through my own like scenario, and I'm sure people at home are doing people listening are doing the same thing. Where you're like, okay, how do I want that to work, and what are the conversations to have to make sure that we know what that is? Because I think in my situation, I mean, there may be some of the benefit, if something were to happen to Emily, my new wife, there may be her ex may actually need to receive something from it because he's going to probably end up with custody of the kids, right? Because that's and we haven't actually had that conversation. I'm thinking about now. I'm like, we're gonna need to talk about that. Like, what do you think? And unfortunately, you hope and pray you do all this planning and that you don't need it. I mean, you eventually need it. You will eventually have an estate to deal with. Somebody will eventually deal with your stuff.
Well, and
you hope it's a long time down the road, but it will eventually happen. Death and taxes. It will happen.
It's really important to understand too. We're talking about some complex family stuff, right?
Yeah.
It's equally important for someone who's single.
Yeah.
Because what's even more important there is if you're incapacitated and you're not deceased, if you don't have any of the documentation in place, right, then who's going to make decisions for you?
Yeah.
Well, somebody that loves you. But Brian, what happens if somebody doesn't have any of those documents in place? They need to make decisions for you. Like, what actually occurs? And you don't have anything in place. How does that work?
Well, very often, if you don't have something in place, you can't make the decisions for that person. So a court has to intervene to give somebody the authority to act on behalf of that incapacitated person. So we have on our website the powers of attorney that people can download and use, and I think it's important that they have that. Okay, because remember I said earlier that if they die without a plan in place, then there is a plan in place under Colorado law that will dictate where their assets go. It may not be where they want them to go, but at least we have that in place. So you should complement that Colorado plan, if you're going to do nothing, with powers of attorney and have those, because it could get really expensive and very frustrating for someone to deal with a situation where the incapacitated person didn't have an existing document saying who is the one that should make decisions for them.
What's your website address?
It's budmanlaw.com. And you can go, there's free resources there. So it's not, we've got a few other things on that website, and it's a good thing to browse through so you can see. We even have some instructions that you can download to leave people as far as where your assets are and who needs to be contacted.
I know another resource I've seen on there, Brian, was, and this is important too for you with young kids. Let's say you go on a honeymoon.
Right.
You leave your children with somebody else. Something happens. They break an arm, whatever. So what can they potentially do for that situation when the two parents are gone?
Well, we have like powers of attorney that you can sign, giving someone the authority to make decisions for your children. Right. And it's really important that you do that because, if God forbid something did happen and they took that child to the hospital, they don't have the authority to make decisions for that child.
Yeah, we run into that here, especially like when we had a youth last summer go on a mission trip, and that was one of the forms that was part of that process was designating someone to be able to take your kid to the hospital if they need to while they're out of state, because they were in New York State. I mean, they were gone, and so that's part of that process too. If with young kids,
and even when you send your children to college and they're over 18, if something happens to them, they should have a power of attorney that they've executed, naming the parents as their decision makers.
Yeah, and I think the single person point is well made too, Roy. I mean, I know, like, I have all my sister's paperwork. My sister is single; she doesn't have any kids, and so I've got all her paperwork, right there next to mine, and in my safe and all that, with for her and her, all of that, so that it's I know that if something happens, who's supposed to do what.
You have another situation that probably needs to be dealt with too.
Oh goodness, what
yeah,
now?
Your son.
Yes.
Who can make decisions for him right now?
That's a good point.
Nobody.
I didn't think about that.
Yep.
Yeah.
But he's the father, Roy.
But he's the father, but his son's 19.
Yeah.
Does he have any authority?
No.
Yeah.
You know, like if something happened to your son.
Don't tell my son that, because he still lives in my house, and I keep reminding him I do in fact have some authority because you live in my house.
Yeah, well, you do have authority because he lives under your roof.
Right.
But if you had to access his bank account
Right.
for whatever reason, you have no authority to do that. You can't go in there and say, hey, well, I'm his dad and he lives under my roof.
What about medically?
Even medically.
Yeah.
Now, you know, I've seen that sometimes. I've seen it where the hospitals are not as strict. But I gave you an example earlier where they were really strict about giving out information. So it's going to depend on who you come in contact with. So you better be armed with the right paperwork rather than just take a chance that you're going to get somebody who's not as strict when you go in there.
Right. Man, I wouldn't even thought about that, but yeah, that makes sense.
So there's a lot of this, and that's why, again, you're not uneducated.
No.
But you didn't even think about it.
Nope.
You know, and even me, be your advisor, I didn't tell you that right away because even I didn't think of that right away, right? But I need to have that built into my process for clients who have children that turn 18.
Right.
Honestly, because even if they're in high school, Brian, do they have any authority if they're an 18-year-old high schooler living under their roof? I mean,
no, once they reach that age.
Once they're 18, you have no authority.
Adults.
Yeah. Yeah. Well, and honestly, there's steps along the way. Like, you know, I'm starting to lose access to part of, like, my daughter has more authority over her, you know, own medical records and stuff now at 14. You know, there's, you know, even younger, there's some places where, you know, they start to be able to make their own decisions around things, you know, even younger, you know, than that even. But yeah, I didn't even think about it. But yeah, now that he's 18. Yeah. And it's like,
so again, this is why the planning piece of this, you know, is a big part for my profession.
Right.
And that's obviously why Brian exists, because it's so complex and there's so many situations that you can see. And then you get a blended family and no one's made the same.
But it complements what you do. Because, you know, as Roy's clients get older, there's always a concern that, you know, like if I notice my client acting differently, making decisions that are really not consistent with their personality.
Right.
Or, you know, being more generous with their money, right? You know, somebody who's just writing checks to whoever comes to their door.
Right.
So who does Roy call? So it would be a good thing if he had something in place that would say, you know, this is someone who I want you to call. This is my agent and a power of attorney. I mean, and you give them the authority, right? And so that way, maybe we have, like, as people get older, I mean, Roy says maybe we should put one of your children on as a co-trustee with you on your trust. In that case, you know, where they can start making decisions for you rather than having to take you to a doctor and have the doctor say, well, yeah, you lack capacity. You just have a co-trustee who's given the same authority, who you've given the same authority that you have to make decisions over your assets.
Yeah, and that was actually a situation where they had a married couple that were together and one passed. Mm-hmm. So as the one passed, it made sense to add a child as a co-trustee at that point.
Right.
But not before necessarily. Yeah. But those are the things that I'll see and I'll say, hey, maybe we should consider this, educate them around it, and then engage an attorney if we need to make that change. But I will tell you, the first time you do an estate plan is not the last.
No.
Life changes, and you need to address those changes as they come up.
Yeah. Yeah. You asked about mine. Well, mine was actually done in the in-between time after my wife passed and before I got remarried. So it's like it's already out of date. It's like we're going to have to change some things.
Yeah, you probably need to change things.
Yeah. I mean, so, well, I think this has been really interesting. And I think, you know, we've talked about this before in other episodes. We end up having to touch in areas that I think people unfortunately kind of want to avoid because you can't not talk about family dynamics. You can't not talk about, you know, things that are maybe kind of complicated. Nobody really wants to sit around and think about, like, the fact that they're going to die someday and they're going to leave an estate. Like, this is something that somebody's going to have to deal with. So, but unfortunately, I mean, we need to deal with it. Like, we need to be able to have those conversations and be thoughtful about it because I like the idea of legacy, right? Like, what do you want, you know, that to be? What do you want people to know about you, what you loved, what you valued, you know, what all that looked like for you in your life. And so I think, you know, it's one of those kind of sometimes unfun tasks of being an adult is, you know, sometimes you gotta think about stuff that maybe you'd rather not, but for a really good reason, because the people that you love and the things that you love, you know, are cared for both now and, you know, in the future. So
as we end here, Brian, is there any big, you know, things you know that you see as being like a real issue out there right now that people need to make sure they're addressing?
Well, I think we touched on it. I think what's important that people have something in place to deal with an incapacity, right? I'm not, I don't want to frighten people to think, well, you got to go out there and get something done. I think you can take your time and put some thought into it, but at the very least, give someone the authority to make decisions for you, because anything can happen. I mean, get on I-25.
Yeah.
You never know what can happen, and so I think it's a good idea that you have those in place, and we've given you an easy way to do it. So. You can download these things and fill them in and have them signed in front of a notary, and you'll have that in place. And then, as a next step, it's probably a good idea to review what your assets and the beneficiaries you have on those assets, and if those beneficiaries accurately and currently reflect your wishes, and you ensure that they're consistent with any type of plan that you have in place.
Yeah, that's one thing I'm implementing. With one of my planning tools, I have the ability to put all their assets in there, whether they're held by me or not. And then we can review that every year. And that's, reviewing the assets I hold with people. Of course, I review those every year, but we're not necessarily getting all the external assets. So we're going to be doing that going forward to make sure that something's not being missed or forgotten or made, accident.
Yeah, like I find that extremely valuable, where Roy might look at things and somebody says, well, I've got beneficiary designations on everything, and the will says everything goes to this person. And so Roy might say, well, the only thing that's going through probate if you die is your house. So maybe we should put a beneficiary designation on that.
Oh.
And so there's ways to do things. There's ways to improve the plans that you have, I should say.
Right.
And so it's really a good idea to get them looked at periodically. And I value that relationship that I have with Roy, because I know he's looking out for our mutual clients as well as I am. But he sees them more frequently, because most people see an attorney once every 5 years, if at all, right? But they meet with their financial advisor much more frequently.
You hope so.
Yeah. Well,
it's a requirement to work with me. So
yeah. Roy
life events are something I'll see happen, and then can encourage those conversations when needed.
Yeah. So, Brian, give us the website again.
It's Budman Law, BUDMANLAW.com.
And then that's where we can find some of those resources you talk about.
Free resources there. And
contact information for you.
For me and for Skylar, my son, who's working with me. And if you have any questions, just feel free to give him a call.
Okay.
I mean, he's got more free time than I do these days. He's going to get busy, though.
Yeah.
So.
Well, like I said, I think when we have guests, Roy, it's always really good.
It is.
I always learn a lot.
It's always good.
So, though I always leave with so much homework. I feel like I got to think
you do.
about that
You
now.
do leave with a lot of homework.
I do. I'm like, oh man. And then unfortunately, that I now know this, and you're going to ask me about it. That's the problem too. That's really wonderful to have an engaged financial planner who holds you accountable to things. It's wonderful, and then sometimes it's not, because you're just fine. And of course, I want to thank everybody for joining us today on the About Podcast. Of course, you can find us on theaboutpodcast.com. Please like and subscribe. If you found this episode helpful, super helpful thing you can do is just share it with your friends or family, or share it on the social medias and all those kinds of things. That really does help us out. So, all right, any final words of wisdom, gentlemen?
Thanks, Brian, for coming. Really appreciate it. It's been insightful.
Me here. Thank you.
Yeah, this has been great. All right. Thank you, everybody.
CWA is a Securities and Exchange Registered Investment Advisor. No content contained herein should be construed as an offer for investment advice or an offer for the purchase or sale of any security, insurance, or other investment product. Investments involve the risk of low loss, including loss of principal. Please consult with a qualified financial, tax, or legal professional before implementing any strategy presented here. Data presented here are obtained from believed reliable sources but cannot be guaranteed as to completeness or accuracy.